In 2011, Alabama enacted what many called the most aggressive state immigration law in American history. The results were catastrophic. Agricultural products rotted unharvested in fields. International corporations found their executives detained at routine traffic stops. Federal courts systematically dismantled the legislation. The experiment ended in failure, costing the state hundreds of millions in economic losses and legal fees. 14 years later, Alabama has returned with an even more comprehensive enforcement strategy. This time, state officials claim they've learned from past mistakes. The evidence suggests otherwise. What unfolds in Alabama over the coming months will serve as a critical test case for similar legislation spreading across the American South. Alabama presents a unique paradox in American immigration policy. Unlike Texas, Arizona, or California, Alabama shares no border with Mexico. Its undocumented immigrant population represents merely 2% of total residents, among the lowest concentrations in the nation. Yet, Alabama has positioned itself at the vanguard of state-level immigration enforcement, twice attempting to construct what amounts to an independent immigration regime within federal constitutional constraints. Understanding why requires examining the intersection of economics, demographics, and political strategy in the contemporary American South. The state's first major foray into immigration enforcement came with House Bill 56 in 2011. The legislation was breathtaking in scope. It criminalized the employment of undocumented workers. It mandated that law enforcement officers check immigration status during any lawful stop when reasonable suspicion existed. It required schools to verify student immigration status. It prohibited the transportation or harboring of undocumented individuals. The architects of this policy believed they could achieve what they termed attrition through enforcement, making conditions so inhospitable that undocumented immigrants would voluntarily relocate. The policy achieved its immediate goal. Thousands of immigrants departed Alabama within months. But the secondary effects proved devastating. Alabama's agricultural sector, particularly its tomato, watermelon, and cucumber harvests, suffered losses estimated at over $200 million in a single season as crops went unharvested. The construction industry ground to a halt as labor shortages paralyzed ongoing projects. Perhaps most embarrassingly for a state courting international investment, executives from Mercedes-Benz, Honda, and Hyundai were detained under the new law, creating diplomatic incidents and threatening billions in foreign direct investment. The legal response was swift and comprehensive. Civil rights organizations, business groups, and the federal government filed multiple lawsuits. Federal courts issued injunctions blocking enforcement of key provisions. By 2013, appellate courts had struck down most of the law's substantive components, ruling that Alabama had unconstitutionally infringed upon federal immigration authority. The state legislature, facing economic pressure and legal defeats, quietly repealed many of the remaining provisions. House Bill 56 became a case study in policy overreach and unintended consequences. For roughly a decade, Alabama receded from immigration headlines. The political environment, however, was merely dormant, not resolved. In early 2025, the Alabama legislature passed House Bill 7, signed into law by Governor Kay Ivey. State officials characterized the legislation as a measured response to federal inaction on border security. Critics saw a repeat of 2011's failures. The actual text reveals something more complex, an attempt to construct enforceable immigration restrictions while theoretically remaining within constitutional boundaries established by federal court precedent. House Bill 7 operates on several parallel tracks. First, it mandates maximum cooperation between Alabama law enforcement and federal immigration authorities. All state and local agencies must honor ICE detainer requests, share custody information, and facilitate federal immigration enforcement operations. This represents a significant expansion of the state's role in what has traditionally been federal jurisdiction. Second, the law targets so-called sanctuary policies with financial penalties. Any municipality or county that limits cooperation with federal immigration enforcement faces loss of state funding. This provision ensures uniformity in enforcement across Alabama's 67 counties, preventing local jurisdictions from creating alternative approaches based on community needs or values. Third, House Bill 7 implements a universal E-Verify mandate. Every employer in Alabama, regardless of size, must use the federal electronic verification system for all new hires. Violations carry escalating financial penalties and potential criminal prosecution. This represents one of the most comprehensive employment verification requirements in the nation. Fourth, the legislation creates new state-level criminal offenses for human smuggling and harboring. These provisions carry sentences of up to 20 years in prison and appear designed to criminalize not just commercial smuggling operations, but potentially anyone who assists undocumented immigrants, including family members and charitable organizations. Finally, the law requires immigration status verification for access to various state services and benefits, with exceptions only where federal law explicitly prohibits such requirements, such as emergency medical care and primary education. The political calculus behind House Bill 7 is straightforward. Immigration remains a potent mobilizing issue for conservative voters in Alabama. Governor Ivey and legislative supporters frame the law as upholding rule of law and protecting state resources. The messaging emphasizes federal failure to secure borders and presents state action as necessary response to federal abdication of responsibility. Yet the underlying numbers reveal a disconnect between political rhetoric and demographic reality. Current estimates place Alabama's undocumented immigrant population between 85,000 and 120,000 individuals. In a state of 5 million residents, this represents roughly 2% of the population. For comparison, undocumented immigrants constitute approximately 6% of populations in both Texas and California. Alabama's undocumented population has remained relatively stable since 2015, showing neither significant growth nor decline. More significantly, Alabama faces persistent labor shortages in key economic sectors. The state's poultry processing industry generates over $15 billion annually and employs tens of thousands of workers. Agricultural production, particularly row crops and specialty produce, requires seasonal labor that historically has proven difficult to source domestically. Construction, hospitality, and food service sectors similarly depend on immigrant workers, both documented and undocumented. This creates the central paradox of Alabama's approach. The state's economy requires immigrant labor. Agricultural economists have documented this repeatedly. After the 2011 law, Alabama attempted to address labor shortages through programs recruiting American workers, including probationers and unemployed residents. These initiatives failed comprehensively. The work is physically demanding, often seasonal, and pays wages that American workers have consistently rejected. No amount of recruitment altered this fundamental economic reality. House Bill 7 does nothing to resolve this contradiction. It increases enforcement and penalties without creating legal pathways for the workers Alabama's economy requires. The result is predictable economic disruption masked by political rhetoric about sovereignty and security. Implementation of House Bill 7 began in stages throughout 2025. The E-Verify mandate activated first, with a grace period allowing businesses to establish compliance systems. Early reports indicate significant challenges. Small business owners, particularly in agriculture and construction, report administrative burdens and technical difficulties. The system has generated false positives, flagging legal workers and creating verification delays that disrupt operations. Some businesses privately acknowledge that full compliance would eliminate substantial portions of their workforce, making operations economically unviable. Law enforcement cooperation provisions have produced uneven results. Some county sheriffs have enthusiastically embraced expanded immigration enforcement, while others have resisted, citing resource constraints and community relations concerns. Detention of individuals for ICE requires jail space, personnel time, and assumes legal liability. Many county facilities already operate at capacity. The financial burden of immigration enforcement falls on local budgets already stressed by limited revenue. The human consequences have been immediate and measurable. Legal immigrants and American citizens of Hispanic or Asian descent report increased scrutiny and discriminatory treatment. Parents fear seeking medical care for children or reporting crimes to police. Workers are relocating to neighboring states with less aggressive enforcement. Communities that were already economically marginal face further destabilization as residents depart and businesses struggle with labor shortages. Legal challenges materialized within weeks of the law's enactment. Civil rights organizations filed federal lawsuits arguing that Alabama has exceeded constitutional authority and violated civil rights protections. These cases advance on multiple fronts. Some challenge the law's facial constitutionality, arguing it intrudes into exclusively federal immigration powers. Others allege enforcement produces discriminatory effects violating equal protection guarantees. Still, others claim specific provisions, particularly those criminalizing assistance to undocumented immigrants, are unconstitutionally vague or violate First Amendment protections. Federal district courts have already issued preliminary injunctions blocking enforcement of certain provisions. The litigation will likely continue for years, potentially reaching the Supreme Court. This legal uncertainty creates additional challenges for implementation and compliance. The broader question remains whether Alabama's approach achieves any meaningful policy objectives. If the goal is reducing the undocumented immigrant population, short-term success is possible, as occurred in 2011, but this comes at substantial economic cost and does nothing to address underlying immigration dynamics. People migrate for work, safety, and family reunification. State-level enforcement does not alter these fundamental motivations. If the goal is protecting jobs for American workers, evidence suggests state immigration enforcement is counterproductive. The jobs performed by undocumented immigrants in Alabama are overwhelmingly positions American workers have declined. Creating labor shortages does not create employment for legal residents. It disrupts economic activity and reduces overall employment as businesses contract or relocate. If the goal is fiscal protection, preventing undocumented immigrants from accessing services, the analysis becomes more complex. Undocumented immigrants in Alabama pay substantial taxes, including sales taxes, property taxes through rent, and in many cases, payroll taxes through false documentation. They receive limited public benefits due to existing restrictions. Comprehensive fiscal analyses of state and local impacts generally show modest effects, either slightly positive or slightly negative, depending on methodology, but rarely economically significant. The reality is that House Bill 7 exists primarily as political theater. It demonstrates to a conservative electoral base that officials are taking action on immigration, regardless of effectiveness or consequences. The policy serves symbolic rather than functional purposes. This dynamic operates within a broader national context. Multiple states, primarily in the South and Southwest, have enacted or are considering similar legislation. Florida, Georgia, and Tennessee have implemented comprehensive e-verify mandates and enhanced law enforcement cooperation with federal immigration authorities. Texas has pursued increasingly aggressive enforcement measures, including busing migrants to northern cities and attempting to create state-level border enforcement mechanisms. This state-level activism responds to perceived federal inadequacy. Conservative state officials argue the federal government has failed to control immigration and secure borders, necessitating state action. But this creates a fragmented, incoherent system where immigration status implications vary dramatically by geography. An undocumented immigrant faces radically different risk profiles in California versus Alabama. This patchwork cannot constitute functional national immigration policy. The constitutional architecture of American federalism places immigration policy primarily under federal authority. This allocation reflects practical necessity. Immigration is inherently a national and international issue. Border control, visa policies, naturalization procedures, and international agreements all require federal coordination. States lack both constitutional authority and practical capability to manage these systems independently. Supreme Court precedent consistently reinforces this principle. The court has struck down state attempts to create independent immigration enforcement regimes, most notably in Arizona versus United States in 2012, which invalidated key provisions of Arizona's SB 1070, legislation similar to Alabama's House Bill 56. The court held that states cannot pursue policies that conflict with federal immigration priorities, and that certain areas of immigration enforcement remain exclusively federal. House Bill 7's architects claim to have structured the legislation to survive constitutional scrutiny by focusing on areas where state authority is clearer, such as employment regulation and criminal law. Whether courts will accept this framing remains to be determined. The legal distinction between permissible state cooperation with federal enforcement and impermissible state creation of independent immigration policy is nuanced and contested. What Alabama demonstrates is the limitation of state-level approaches to national challenges. Immigration policy requires comprehensive federal reform addressing border security, interior enforcement, legal immigration pathways, and status resolution for long-term undocumented residents. Absent such reform, states oscillate between extremes, either attempting aggressive enforcement that proves economically and legally unsustainable, or creating sanctuary jurisdictions that generate their own tensions with federal authority. Alabama's experiment will provide data points. Economic indicators will reveal whether enforcement produces labor shortages and business disruption comparable to 2011. Legal proceedings will test constitutional boundaries of state immigration authority under current Supreme Court composition. Demographic data will show whether undocumented immigrants depart and whether legal immigrants and citizens face increased discrimination. Political outcomes will indicate whether enforcement rhetoric translates to electoral success. But the fundamental question is not whether Alabama's approach works in achieving stated goals. The evidence from 2011 and from similar policies elsewhere suggests it will not. The relevant question is what this reveals about American immigration politics. States are implementing policies they know are likely to fail economically and legally because the political incentives favor action over effectiveness. Immigration has become a theater for demonstrating ideological commitment rather than a policy area where outcomes matter. This dynamic cannot produce a functional immigration policy. It generates instability for businesses, insecurity for immigrant communities, and legal uncertainty that persists for years. It consumes state resources in enforcement and litigation that could address actual governance needs. And it does nothing to resolve the underlying policy challenges that make immigration reform politically intractable at the federal level. Alabama's approach should be understood not as a serious policy solution, but as a symptom of deeper dysfunction in American immigration politics. Until the national political system can produce comprehensive reform that addresses both security and economic realities, states will continue these experiments. They will continue to fail, and the cycle will continue, producing human suffering and economic disruption without resolving the underlying challenges that make immigration one of the most complex policy issues in American governance. The question is not whether Alabama will succeed where it failed in 2011. The question is how much economic damage and human cost will accumulate before political leaders acknowledge what evidence has repeatedly demonstrated. Immigration is a federal responsibility that requires federal solutions, and state-level enforcement, no matter how politically popular, cannot substitute for comprehensive national policy reform.